And we request now Sri R.P. Singh ji, Director HR IFCO, to please come on the dais. And now we request Mr. A.K. Lahoti, our chief guest, ex-chairman Railway Board, to please come on the dais and welcome him to the classroom of science. Now, these people, our dignitaries, have arrived on the dais. Let me give a brief about our dignitaries for you people to know about him. Now, we begin with Mr. Sandeep Mittal, our President, Noida Management Association, and Mr. S.N. Singh, both of them are your host also. Sri Sandeep Mittal, he is working as a CFO in Holistic India Limited. He is a chartered accountant, company secretary and law graduate, having more than 30 years of professional experience. His personal motto is to work for empowerment of less privileged through knowledge sharing and mentoring. Warm welcome to you, sir. Sri S.N. Singh is a Vice President HR Influx Limited and past President of Noida Management Association. He is a MSW from Agra University and has more than 35 years of experience in the field of HR and industrial relations. Prior to Uflex, he worked with Century Pulp and Paper and Kesoram Rail Limited. Warm welcome to you, sir. We also extend our welcome to Dr. Jogendra Singh, our Senior Vice President, Noida Management Association. Sri Dinesh J, it is a great pleasure to welcome you, sir. Sri Dinesh Jain is a MBA, LLB and LLM gold medalist. Presently, he is holding position of President, Legal and Corporate Affairs of Uflex. He is a past President of India. His name is synonymous with Noida Management Association because the contribution that he has made to this association is immeasurable, and let us welcome him with hands of clap. Sri R.P. Singh ji is a veteran professional. He is a director of Indian Farmers Fertilizer Cooperative Limited, that is called IFCO, which is one of the largest manufacturer and marketer of fertilizer in Asia. Mr. Singh is also a part-time director on the board of PhD Chambers of Commerce and Industry, Kisan International Trading, IFCO MC Crop Science Private Limited, IFCO Chhattisgarh Power Limited. He is having more than 4 decades of vast experience of human resource management. A very warm welcome to you, sir. Dr. S.V. Mitra, welcome you, sir. Dr. S.V. Mitra is an executive director HR and Legal GAL India Limited. Ex-executive director HR and Legal GAL India Limited and is presently advisor Director General of Hydrocarbons, Ministry of Petroleum and Natural Gas. He has a vast experience of human resource management and profound knowledge of legal matters. He is also presently associated with number of educational institutions. Warm welcome to you, sir. And now our chief guest, Sri A.K. Lahoti, belongs to the Indian Railway Service of Engineers. and has held several important positions in the organization. Sri Lavati graduated in civil engineering with gold medal from Madhav Institute of Technology and Science, Gwalior, and did his Masters of Engineering from University of Roorkee. He is a former chairman and CEO of Railway Board. Warm welcome to you, sir. Now, after the brief description, we request our dignitaries to come for lightning of lamp. Now, it is customary for us to honor our guest. We request Sri Dinesh Jainji to honor our chief guest, Sri A.K. Lahoti. Now, we request Dr. Jogendra Singh, our Senior Vice President, Noida Management Association, HOD of JSS Engineering College, to honor Sri R.P. Singh ji. Now, we request Sri Sandeep Mittalji, President Noida Management Association, to welcome Sri Dinesh Jain. honor Mr. Dinesh Jain. Now, Dr. S.B. Mitra. Dr. S.B. Mitra, when I spoke with him, he is our program director, he is everything. And today's program is all what about Dr. Mitra has helped us. So we want to honor Dr. S.B. Mitra also. And Sri S.N. Singh Sahab will honor him, Dr. S.B. Mitra. I'm going against your wishes, sir, but you are, we can't do it. Now, to start with the program, before we start the program, we request now Mr. Sandeep Mittal, Noida Management Association, to say a few words about NMA. Say Sandeep Mittal.
Good morning. A.K. Nawaki साहब, R.K. सिंह साहब, दिनेश जैन साहब, S.B. मित्रा साहब, S.N. सिंह साहब, डॉक्टर योगेंद्र, सुभाषिष मित्रा जी and Mr. Bharti, and all the participants जो इस सर्दी के टाइम में, ठंड के टाइम में हमारे पास यहाँ पर they have just come to attend this program, this wonderful program. I welcome you all here and अपने तहे दिल से आपको thank you बोलते हैं माननीय from the Noida Management Association. You might be knowing about Noida Management Association. This is a organization, affiliated to All India Management Association, established in 1989. So we work in basically to promote knowledge sharing and the interact. This is a platform to interact to each other, the professionals, non-professionals, with the industries, non-industries, individuals. So we keep on doing the programs like that in this platform, on this Noida Management Association program. So इसी direction के अंदर we have organized this program on this very wonderful subjects on Right to Information Act and Sexual Harassment Act. Both the programs, are of very much importance in the day-to-day life for the organizations, from the various entities, individual level के ऊपर भी these are very important Right to Information Acts like this. Just to simply there are so many intricacies among the acts, but अगर simply तरीके से इसको हम सोचने की कोशिश करें या कुछ हम समझने की कोशिश करें कि ये क्या है, ये किस लिए बनाए गए हैं, क्या मतलब इनका पर्पस क्या है, तो एज फॉर ए राइट टू इंफॉर्मेशन एक्ट जो हमारा एक फर्स्ट टॉपिक है इसके अंदर, जिसके ऊपर हम सारे दिन के अंदर काफी डिस्कशंस करेंगे. Basically, in general, when you are just in day-to-day life, also sometimes you think like this कि गवर्नमेंट जो डिफरेंट टाइप के काम करती है फॉर द सोसाइटी एट लार्ज या किसी इंडिविजुअल की बेनिफिट्स के लिए कुछ स्कीम्स देते हैं, कोई सोसाइटी के लिए स्कीम्स लॉन्च करते हैं, कुछ करते हैं, तो कभी ये क्वेश्चन आते हैं यार ये सब गवर्नमेंट जो कर रही है क्या कर रही है, इसके लिए मतलब हाउ दे कलेक्टिंग द मनी, हाउ दे स्पेंडिंग द मनी, तो मुझको जानना है. कभी कभी इच्छा होती है कि ये क्या कर क्या रहे हैं, मतलब ऐसा करके sometimes this question arises in each and every person's mind, कभी भी हो सकता है. So to satisfy this quest of the individual, this Right to Information Act 2005 is devised. किसी मतलब this is treated as fundamental right of the human being. मतलब Indian Constitution में right to information is a fundamental right basically. तो इसके अंदर any individual, any organization can seek the information from the government about their activities. ये जान सकते हैं हम लोग, अगर हमारा कोई क्वेश्चन है किसी गवर्नमेंट एंटिटी से, किसी गवर्नमेंट ऑर्गेनाइजेशन से, गवर्नमेंट एफिलिएटेड ऑर्गेनाइजेशन से, या किसी ऐसे क्लब से, स्पोर्ट्स एसोसिएशन से, तो जो भी गवर्नमेंट कंट्रोल होते हैं, बिकॉज वट एवर द गवर्नमेंट डू, दैट द गवर्नमेंट डू फॉर द सिटीजन ऑफ इंडिया, आप लोगों के लिए, हमारे लिए, सबके लिए करते थे, द रिप्रेजेंटेटिव ऑफ अस ओनली। सारा कुछ जितना भी कंट्री है, कंट्री तो सिटीजन्स का है, दे आर द ऑनर ऑफ द कंट्री बेसिकली। तो गवर्नमेंट को उन्होंने बैठाया है, बनाया है, नॉमिनेट किया है अपने कामों को एग्जीक्यूट करने के लिए, तो हमारे को राइट है कि वो हमारे लिए क्या कर रहे हैं, हमारे पैसा कलेक्ट कर रहे हैं, हमारा पैसा स्पेंड कर रहे हैं, तो कहाँ कर रहे हैं, ये हमारे को राइट है। तो दिस राइट टू इंफॉर्मेशन एक्ट एम्पावर द इंडिविजुअल टू सीक द इंफॉर्मेशन फ्रॉम द गवर्नमेंट। भैया आप क्या कर रहे हैं, आप हमें बताइए, हम आपको ये एप्लीकेशन डाल रहे हैं, आप हमारे को इसकी सोर्सेज बताइए, एक्सपेंडिचर्स बताइए, आप अपनी प्लानिंग बताइए, आपके माइंड में क्या है, इसकी हमको जानने का अधिकार है। तो दिस इज द एक्ट बेसिकली टू एम्पावर द जनरल पब्लिक। तो अभी डे टाइम में आप काफ़ी सारे इंप्लीकेशंस, इनमें बहुत सारे चीज़ें हैं इस एक्ट के अंदर, जो सब्जेक्ट एक्सपर्ट हैं वो आपके साथ इसके बारे में डिस्कस करेंगे, बताएंगे कि किस तरह से हम RTI एप्लीकेशन लगा सकते हैं, क्या कर सकते हैं, क्या नहीं कर सकते। ऐसा नहीं कि बिल्कुल ही अनचैलेंज्ड सारे राइट्स हैं इसके अंदर, बहुत सारे इशू ऐसे होते हैं जिनके अंदर आप शायद नहीं घुस सकते हैं, जैसे सिक्योरिटी से रिलेटेड हो सकते हैं, जो नेशनल सिक्योरिटी से संबंध रखते हैं, इस टाइप के इशू हो सकते हैं जिसमें आप नहीं घुस सकते हैं, उसमें RTI नहीं लगा सकते हैं। तो ये बहुत सारे सब्जेक्ट्स हैं जो डे टाइम के अंदर आपको पता लगेंगे कहाँ पर आप RTI अप्लाई कर सकते हैं, कहाँ नहीं कर सकते हैं, किस तरह से कर सकते हैं, उसका प्रोसेस क्या है, उसकी फीस क्या है, उसको कैसे चैलेंज कर सकते हैं, एवरीथिंग यू विल नो इन द डे टाइम। तो वी थिंक दिस विल बी ए वेरी यूजफुल सब्जेक्ट, जो किसी भी इंडिविजुअल के लिए बहुत इंपॉर्टेंट हो सकता है। द सेकंड सब्जेक्ट, सेक्सुअल हरासमेंट ऑफ वुमेन एट वर्क प्लेस, दिस सब्जेक्ट इज आल्सो वेरी इम्पोर्टेंट। आप डे टू डे टाइम के अंदर वैसे भी मतलब यू माइट बी गोइंग थ्रू वेरियस न्यूज़, वेरियस न्यूज़पेपर में आती हैं, टीवी में आती हैं, इन जनरल आपको पता है कि देयर आर ह्यूमन हैरेसमेंट हियर एंड देयर, किसी भी तरीके से करके कोई अब्यूज़ है कि कोई किसी को गलत तरीके से बोलता है, कोई बिहेव करता है, या कुछ इस तरह की चीज़ें करते होती हैं। मतलब ये सोसाइटी के अंदर कहीं कहीं चीज़ें ऐसी हैपनिंग्स होती हैं। तो इस तरह की हैपनिंग्स को कर्ब करने के लिए, इस तरह की हैपनिंग्स ना हो, वुमेन शुड फील सेफ एंड डिग्निफाइड इन द सोसाइटी। उनको ऐसा लगना चाहिए कि एट द वर्क प्लेस दे आर जस्ट सेफ, दे कैन वर्क विद डिग्निटी, दे कैन वर्क विद ड्यू रिस्पेक्ट, किसी भी वर्क प्लेस के अंदर, किसी भी ऑर्गेनाइजेशन के अंदर। तो ये एक सेक्सुअल हरासमेंट वुमेन पॉश एक्ट वाज फॉर्मुलेटेड टू प्रोटेक्ट द डिग्निटी, टू प्रोटेक्ट द व्यूज टुवर्ड्स द वुमेन। ये एक्ट को फॉर्मुलेट किया गया। इसके अंदर भी देयर आर सो मेनी प्रोविजंस लाइक दिस, मतलब वो फिर दोबारा वो सब्जेक्ट एक्सपर्ट्स आपको पूरा एक्सप्लेन करेंगे कि जैसे आप कौन ऑर्गेनाइजेशंस में कवर है, किस तरह से कमेटीज इस्टेब्लिश होती हैं, हाउ द कमेटी कंडक्ट इंक्वायरीज, उनकी क्या पावर्स हैं, वुमेन पावर्स क्या हैं, जिसके अंदर वो इसको दे कैन पुट देयर एप्लीकेशन, या दे कैन जस्ट seek the redressal of their grievances like this. So many provisions are there. The subject expert will explain you about this. आप लोग उनसे इंटरेक्ट करिए, आप लोग जानिए, आप लोगों के क्वेश्चंस उसके अंदर I can see so many moments here, मतलब this itself shows the the importance of the subject, कि सबको जानने की इच्छा है कि हमारे को क्या एक्ट में प्रोवाइड किया है गवर्नमेंट के, जो हमारे लेजिस्लेशन में इतने सारे एक्ट्स प्रोवाइड किए गए हैं, वो किस चीज़ को प्रोवाइड करने के लिए किस तरीके से उनको यूज़ कर सकते हैं अपने बेनिफिट्स के लिए, इस तरह की ये सब चीज़ें इसमें हैं। तो आप लोग क्वेश्चन करिए, आप लोग उसके अंदर क्वेश्चन करके आप लोग उसके बारे में जानिए, अच्छी तरह से मेमोराइज कीजिए, और आपको प्रैक्टिकली उसको कहीं पर अगर आपको ऐसा लगता है कि भी आपको इसकी ज़रूरत है, या इसके अंदर आपको कहीं पर सपोर्ट की ज़रूरत है, तो आप उसको सपोर्ट सीख करिए। कहीं पर भी जाकर आपको पता होना चाहिए कि आपके राइट्स क्या हैं, आप किस तरीके से करके आपके साथ में ऐसा बिहेवियर ऑर्गेनाइजेशन में होना चाहिए, क्या होना चाहिए, ये सब आपको पता होना चाहिए। दिस इज द मेन रीज़न। हमको लगता है कि ये दोनों ही एक्ट बहुत इंपॉर्टेंट हैं, किसी इंडिविजुअल के लिए, किसी ऑर्गेनाइजेशन के लिए बहुत ज़्यादा इंपॉर्टेंट है। इसीलिए हम लोगों ने ये प्रोग्राम को ऑर्गेनाइज किया है, और आपने इसको काफ़ी अच्छे लार्ज नंबर्स के अंदर अटेंड किया है, इंटरेस्ट शो किया है। दिस अगेन शोज द इम्पोर्टेंस ऑफ दिस प्रोग्राम। और हम आप लोगों के थैंकफुल हैं कि आप लोगों ने हमारे को अच्छे सपोर्ट किया। सो नाइस ऑफ यू, थैंक यू वेरी मच एंड वेलकम टू द प्रोग्राम।
Thank you, Mithal Sahib, for saying some good words about the program and all that. Now, before we invite our expert, our two experts, I will request Dr. S.B. Mitra to give an outline about the program. What is this program about and what are the things that we want to cover it about? Dr. S.B. Mitra, sir, please.
Very good morning. Respected Laudi Sahab, our chief guest today. Respected Mr. R.P. Singh, Mr. Dinesh Jain, our guest of honor. Respected Mr. S.L. Singh, respected Mr. Mitra. On the dais, my friends and delegates from the legal editor fraternity, and also Mr. Rural and other important office bearers of the dais. At the very outset, let me express my sincere thanks to NMA for giving me this opportunity to be here to share my views. I am very thankful to Mr. Lahoti, who has given kind consent to be here to be the chief guest of today's function. My relationship with Mr. Lahoti goes back to my days in Vijaypur and in the district Guna for about 33 years. In fact, I used to know there are 4 brothers, and I used to hear a lot about him, but I never had the occasion to meet him. Had I not attended that PT Governing Council meeting where he was there in Federation House. So when I could meet him, then I made a request to him, and he was gracious enough to accept this, role. In fact, Mr. Lahoti happens to be a very small district town of Madhya Pradesh. And all his brothers are so well settled. जिनको कहा जाता है उनको माता जो हैं वो रत्ना गर्भा जो बोला जाते हैं in true sense. लाहौटी साहब का एक ब्रदर को आप लोग जानते होंगे, मिस्टर R.C. Lahoti. He was the chief justice of former Chief Justice of India. उनको दूसरा ब्रदर जो है वो भी मिस्टर के लाहौटी हाईकोर्ट का जज थे. उन्होंने former chairman of the Mr. Lahoti of the railway board, and most interestingly is one of his brothers, Dr. Lahoti. He is a very popular person in the district, in Guna district. When we were setting up our projects over there, he voluntarily agreed to come and visit our family and to provide medical consultation. Anyway, if I have to speak about Mr. Lahoti, it will take a long time. Mr. R.P. Singh, yes, he is again our mentor in this profession. My relationship goes back to 1998 for more than 25 years. In fact, I was his successor. He was the chairman of Delhi NCR chapter of NIPM. Then I took over from him. Mr. Dinesh Jain, again, we worked together for years together, and Mr. Dinesh Jain, in fact, was my successor he took over from me as the chairman of the NCR chapter. Mr. SNC, my relationship goes to him again, from the NLPM days. Mr. Mittal from the Noida Management Association. Let me come back to the subject because I'm very passionate about these two issues. Right to Information Act. When you look at the statute, the two words, we have to play with the two words. One is right and second is the information. When you talk about right, as rightly pointed out by Mr. Mittal, that right that is conferred to the citizens of this country by none other than the supreme law of this country, that is the Indian Constitution, under Article 19. The question comes up whether this right is an absolute right or it comes with the restriction. Yes? If you look at the same article, Article 19.2, it talks about it comes with reasonable restriction. So no right is absolute. Right? Now if you look at the information, yes, any piece of knowledge is an information. And there is a popular belief that information leads to knowledge, knowledge leads to empowerment, and that is how, if the citizens are knowledgeable and they have information about the functioning of the government institutions, then it will bring more transparency and accountability to the functionaries of the government institution, and that will ultimately contain the corruption. That's the belief. Now, public sectors as an instrumentality of the state under Article 12 of the Indian Constitution is covered under the definition of public authority under the definition of Section 2H. So therefore, it gets quietly covered and they are under obligation to disclose information about the functioning of the institutions, though it is a commercial entity. Now, if you look at the statute in the preamble, it very clearly spells out that this is an act to provide for setting out practical regime of right to information. I need to emphasize on the word practical regime. So anything that does not meet the practicality, does not serve the purpose of the ground reality, such informations are not required to be disclosed. I know the maxim of this statute talks about maximum disclosure and very minimal exemption. So I would like to give little citations from the Supreme Court. In fact, Supreme Court of India, this issue traveled up to the Supreme Court of India because the statute came in 2005 and the law was getting evolved during that period of time. And maximum, the landmark judgment came out in 2009 to 2012. In one of the judgments, the Chartered Institute of Accountants of India, Supreme Court set out the objectives of the RTI Act. It says, yes, it is an established fact that there is an inherent conflict between information seeker and the information giver. There is dichotomy. When a giver becomes a seeker, he feels highly empowered, but he does not feel much comfortable in disclosing the information. That's a different issue. But there is an inherent conflict, and therefore the Supreme Court came out in saying there must be a mechanism to harmonize the conflict of interest between the information seeker and information giver. The second point is very much important because the public sector, in particular from the perspective of the public sector, although it is covered under Article 12, covered under Section 2H of the RTI Act, but it is like any other private sector, is a commercial entity, and therefore the cornerstone for every public sector is only and only to pursue the commercial interests. And therefore, Supreme Court, having recognized that, said that the statute should not lead to put the PSUs or the institution in a difficult situation to compromise the commercial interest. So that needs to be always kept in mind. Second, thirdly, that PSUs or any institution, they have their core activities to pursue, and therefore it should not lead to unnecessary, the wastage of fund, public exchequer fund for disclosure of the information. That is again very important. And the fourth objective that has enunciated that confidentiality, that can never be compromised. So, therefore, I must say that those who deal with the RTI must be remembering all these objectives before disclosure of such information. I had the privilege of being the CPIO for years together, and I was a part of the steering committee of the scope. Mr. Khawal is here. He is an RTI expert. I was the chairman of the legal standing committee and here. So Khawal sahab is to lead the RTI, across the country among the PSUs. So it is very interesting that statute does not prescribe for compromising the interest of the institution by disclosing the information. This is very important. I cite 2-3 other statute by important judgments. One judgment is the Atulu Bandyopadhyay versus CBSE. I am sure that Mr. Khawal is like to cover that access to information not at the cost of the institution. The 75% of the people should not remain busy in providing or organizing, information for the RTI applicants. That's very important. Similarly, the personal information that cannot be disclosed to any third party, and for which there are two important judgments. One of the judgments became so popular that it was circulated by none other than the Central Vigilance Commission among the PSUs. I am sure Khawal sahab is likely to cover that Yes. Over that judgment also. There is another judgment, the Canara Bank judgment on the same issue. So the point I am trying to say that Article 21 guarantees as a fundamental right the personal dignity and liberty. So that should be kept at the highest esteem, and that cannot be ignored or compromised while furnishing information. I had the privilege of traveling to many places along with Mr. Korwal, and wanted to share the dais with the Information Commissioner. And one Information Commissioner, Mr. Professor Acharya, he used to always say, "जो मैं जो भी कहूँगा मित्र सब उसको उल्टा कहेंगे." So because Section 8(1) provides you the instrument or the mechanism when to say no, when to seek exemption. I like to classify them under 3 heads. One is the commercial interest. That's very important. That is the prime factor for the commercial entities. Second, the personal information. Third, the third-party information. You should be very careful while furnishing the information. And I had that opportunity to deal with this subject because there are only 2, decisions of the CIC where the CPIO has gone against the decision of the first appellate authority. If you know the structure, it is the CPIO, then first appellate authority of the same institution, and then the second appellate authority of the commission, State Information Commission or Central Information Commission. So when I was CPIO, there was an application seeking information about the question papers of the day and with the answer keys, because we used to conduct examination for the recruitment of the engineers. So I have immediately replied that these informations are not to be disclosed. But I was on leave. When I came back, I found that my first appellate authority given the direction, my boss, given the direction to disclose the information. I was aggrieved, and when I am aggrieved, I generally do not, obey the order. And I took a conscious call that I will not furnish the information. I have gone to CIC. And Information Commissioner बोल रहे हैं मित्र जी क्यों पंगा ले रहे हैं? आपको पहले का जो CPIO थे वो तो 25,000 दावा के गए हैं. He had paid probably 1,000 rupees. अगर आप हार जाओगे, मैं बोला सर I want to prepare an appeal against the decision of my boss. I don't want to agree with him. तो उन्होंने बोला 25,000 आपको देना पड़ेगा. I said I am ready. Then मैंने उनको appeal put up किया. I have prepared an appeal. There is a series of presentation. I was making presentation on the other side. Advocate from the the RTI applicant, that lady, वो चला, and I could prove and establish that lady was seeking information because she used to run the coaching institute, and it was for a wrongful gain, and no public interest at large is likely to get served. And मुझे 25,000 देना नहीं पड़ा. I had won that case. Similarly, after 2 years, another boss of mine, मैंने ना कर दिए क्योंकि there used to be series of information उन्होंने मांगा है. So if you look at the statute, जब इंफॉर्मेशन तो पहले एन लिखा रहता है तो एन मतलब सिंगल इंफॉर्मेशन, रिक्वेस्ट का पहले ए लिखा रहता है मतलब सिंगल रिक्वेस्ट होना चाहिए। तो हमने सिंगल रिक्वेस्ट को अलाउ किया, बाकी को नहीं किया है। नहीं करके मैंने बोला उनको तुम 26 एप्लीकेशन डाला, 25 का तो तुमसे 25 एप्लीकेशन अलग अलग डाला तो मैं आपकी इंफॉर्मेशन दूंगा। माय बॉस वाज नॉट वेरी हैप्पी, बोला दे दो यार क्या फर्क पड़ता है। तो यहाँ पे एक कहावत है कि फर्क पड़ गया दे दो, तो हमने बोला ना मैं तो नहीं दूंगा। फिर अगेन दैट वाज द सिचुएशन, ऑर्डर पास बाय हिम। आई हैव गॉन टू द CIC। मैं बोला सर मैं तो 25,000 है यहाँ पे, लेकिन मैं तो चैलेंज करूंगा। एंड चैलेंज किया है, यू विल बी सरप्राइज्ड टू नो इट टुक मोर देन अ ईयर और सो एंड फाइनली आई हैव वन। So, if you are convinced, then there are ways to, vindicate your views. Let me not speak much about right to information. Posh को बारे में तो इससे जुडिशियल एक्टिविज्म मुझे बोलने का मौका नहीं दे रहा है इन्होंने, बोल रहा है टाइम बहुत हो गया है, तो ठीक है, because I don't want to make delay further. If I get an opportunity during this session, I will interact with people. Thank you very much for giving me this opportunity. I welcome Dr. Subhash Gupta. He is a veteran, management and legal consultant. In fact, it is his inspiration that I did my PhD both in management and law. So, thank you very much, sir. Thank you so much.
In continuation of the program, in between we welcome Mr. Subhash Gupta. We also welcome our Vice President, Noida Management Association, Dr. V.K. Tomar, Dean, Jaipuria Institute of Management. Thank you so much, sir. And now I will call upon Sri Dinesh Jainji. I want to say something on the subject to our delegates. Sri Dinesh Jainji.
Good morning. Very happy to see all of you here in this very, very important program. I am really grateful to NMA, Dr. Mitra, President Sanjeev Mitra, and of course Vishal, who always runs NMA in the right manner. I am also thankful that today I have been introduced to Mr. Naughty. I never met him, but it reminds me his elder brother, Mr. R.C. Naughty, who was the Chief Justice of Supreme Court of India, and the most dedicated and honest judge in the country. He was a very good friend of mine for the last 33 years, so we lost him recently. Thank you very much that I have been introduced to Mr. Jaitley also today. And R.P. Singh, of course, he is elder to me in age, elder to me in experience. Probably he has put in almost 47 years, and I am in this field for the last 45 years now. With God praise. And this topic, because Mr. R.P. Singh has cautioned me, don't take more than 5-6 minutes, and I have to honor him, not only because he has cautioned me, but also because for the simple reason that you all are here, and my eminent speakers, and the first session starts at 11:15. So I will not come in the way of that session. Though I had brought a lot of things, I thought I will be given 15-20 minutes, but anyhow, I will try to sum up in 5 minutes. This topic is a wonderful topic. You see 2013, Posh. But almost 9-10 years have gone, and today we are dictated by the district magistrates through various orders. You have not framed the committee in the office, you have not framed you don't file the returns, you don't have awareness programs in your companies. What is this? A simple act. How many pages is this? I think not more than 17 pages. I would request all of you to buy this act today, if you don't have, and read this act thoroughly, only few pages of the act and the rules. See, this is a fundamental right. Why Supreme Court will direct you in various cases? Recently in 2023, Supreme Court has issued directions now to the district magistrates, to the authorities, to the government, to why this act is not being enforced, why this act is not being strictly implemented in the various organizations, whether it is the private or in the statute government bodies. You know, various sections clearly provide you. In filing the return, annual return of this act, you have to mention clearly how many programs you have attended, how many awareness programs you have attended. Either few companies give a wrong information to the DM and send. Why? See, we have got all the committees here. Most of the companies have committees. What you have to do simply, you have to learn, you have to go through the act, and the presiding officer of the committee has to take the lead in making all the members aware of this act, of their rights, of their duties. If that is so, why today Government of India, Honorable Prime Minister of India, everybody is saying equality to freedom, liberty, right of liberty, of the woman, state of the woman, that we keep on speaking. But in actual terms, if we cannot exercise our right, then where is the freedom, where is the liberty? So my request to all of you is that go through the act, and every company here, whether we have got HR managers or we have got other managers or CEOs or whatever, if the committee has not been formed, don't treat it as a statute. Treat it as your own fundamental right to exercise, make a committee, and organize a lot of awareness programs. Why this program is important? Because this is also part of your act and the rules where you have completed one program today. You can file in your annual return when you file it before the district magistrate that yes, this is one program we have attended. And fortunately, you have lot of experts coming, lawyers from Supreme Court, a lady lawyer coming, and other experts are coming who will devote enough time with you. I would have loved if Mr. Mitraji, who is an expert in the subject, would also explain, give some time in the afternoon issue. I don't know if the schedule, it doesn't seem so, but he has an immense knowledge of the subject. RTI, you know about RTI, experts will speak. I think another 1 minute left with me. So RTI, again it applies to private, it doesn't apply to private. See, we all are sitting here. Then certainly it applies to government, what information one can seek, then what are the privileges, where RTI information cannot be ruled out. There are a lot of rulings mentioned in the Supreme Court. There was a ruling from the Commission, Central Commission of India, where they have simply said that in RTI and this Harassment Act, see there is a combination, experts will explain to you. Harassment Act and RTI. If any information about the Harassment Act through the RTI is seeked by the lady who has been harassed under the Act, now question is whether they will provide or not. Up to High Court, up to various courts, it's also said no, it cannot be, it is exempted, but certainly the Central Commission of India, they have clearly mentioned and ruled out, no, yes, they have a right, a woman who has been aggrieved under the Act, she has a right to apply and ask information under the ID Act for this Sexual Harassment Act, what is the progress, what is the status, what is the result. So they have been said, well, it doesn't come in the exemption. Only exemption comes is what? If the information relates to media, to the press, then there, of course, the restrictions are there. So I hope, I am sure this program will be very, very useful to you. I have been always attached with the railway, being a ex-past president, Mitraji brought me. So RP Singh Saab took me to NIPM. There also I spent few years with NIPM, so all the experts are here. And you all should, again, my final request to you, learn, read the whole act. You learn a lot of good things out of it. For your own self, for the other female employees, so that they have equal right and liberty to work with freedom and with good status. So thank you very much. And this program, we wish a success to the program. And I hope RTI Singh Saab have not taken more than 7 minutes. So thank you very much.
Now we request Sri RTI Singh Saab, Director HR IFCO, to share his thoughts on the subject, please.
Thank you, Mr. Mishra. And our respected Chief Guest, Mr. A.K. Lahoti, Chairman of the NMA, Mr. Sandeep Mittal, our dear friend, Dinesh Jain, Mr. S.M. Singh, Dr. Mitra, who was instrumental in bringing me here for this program. My sincere thanks to all of you and to Noida Management Association for giving me this opportunity to be here. Now I must appreciate the choice of topics. They are really contemporary and most essential for all those who are working in organizations to know. And even for those who are not working, it is a very important piece of legislation. In fact, both these legislations are very important and you must know about it. The problem with these kinds of seminars or conferences where the number of speakers are more is that the possibility of repetition is great. So I will try to confine myself to some of the peripheral aspects and also like to share with you some of my own experiences rather than going into the provisions of the law for which the experts are already here and they will be speaking about it in greater detail during the course of the day. So we have 2 acts about which we are going to discuss. So before I start talking, let me know how many of you are from public sector and how many of you are from private sector. So starting with private sector, please raise your hands. How many are from private sector? Right. So when it comes to RTI Act, the role of those in private sector would be different and those in public sector would be different, because those in private sector are sitting in the role of information seekers and those who are in public sector maybe sometimes they are also in the role of seekers, but most of the time they are information providers, because the law is meant for providing information by public authorities, and that's a very small word, but that has been debated a lot and adjudicated upon by various courts, and a concept has evolved. So rather than speaking in generalities, I will discuss IFCO's case where we were very successfully able to convince the courts and the CIC that we are not a public authority. So, see, when it comes to enactment and implementation of laws, you all will be aware that the people who are behind the framing of a law are a small number of people. Parliament has some 500 and odd members. Some bureaucratic machinery is there who drafts the law. Certain discussions take place in the standing committee and all of them. The law is enacted. When it comes to enforcement and interpretation and circumventing the law, the number is very large. Millions and millions of people try to find loopholes in that law, try to see how this law should be enforced or how this law should be violated. So the real test of the law comes when it is put into use. The most important aspect in this connection is that we should all be very honest when we are going to use the law, going to enforce the law, and we should not be at the core of our heart a basic intention of circumventing the law. So my request to all of you would be that implement the law as it is, because it gives you a very valuable right to citizens, and this right must not be misused. That's why Dr. Pratt said in the very beginning that rights are not absolute. Rights are tempered with reasonability. You have to be reasonable in your approach, and you have to first see whether what you are asking for is really for the public good or for serving your own selfish interests. Now coming to the definition of public authority under RTI Act, I'll just share you a story because that will be more entertaining than hearing the lecture. So, you know, most of you, if you are in the field of RTI, would know the name of Mr. Subhash Chandra Agarwal. He is a very famous RTI activist who lives by asking questions and going to the RTI office, the CIC office, and representing cases and winning or losing or whatever. So once our chairman, Mr. Surinder Jakar, he died of some accident suddenly. So since IFCO has cooperative societies, about 36,000 cooperative societies all over the country who are our members, it was thought prudent to give an obituary in newspapers all over the country, because the members are from different states, knowing different languages, so that obituary was given in different languages: Tamil, Telugu, Assamese, Punjabi, Bengali, English, Hindi. Now Mr. Subhash Chandra Agarwal asked a question to us, that how much money has been spent on these newspaper advertisements? Why this public money was wasted? We said that this is none of your business. He was our head of family. Anyone who, in the family, if someone who is head of the family passes away, there is a convention of publishing an obituary. Whether that obituary should be published in 10 languages or one language, that depends upon the popularity or reach of that person. He went to CIC. We said that we are not a public authority. Then a hearing, as usual, a hearing was fixed by CIC. We went there. We argued. He had taken some data from the public domain. Initially, we used to have some government equity which had been returned, and we didn't have any. So the points that he took was, look, in their address, website address, the email ID, It is ifco.nic.in. NIC is only for government. Luckily, before he took this plea, we had already changed it and we have removed NIC. So that was also, he lost. Then government equity was not there. Then he was, if you see the definition of 2H of public authority, it talks about control and aid by government. So it's not only that you must be only a government department or 100% owned public sector undertaking. It could be an organization where government has some financing. When he found that we had no equity and we were independent, then he was harping on control. There also we were able to convince CIC that, look, control is defined by the power of the government appointed directors with elections. All those are absent. So there is no control. Then he started reading out of the Multi-State Cooperative Societies Act, which governs us. So in those laws there would be a provision that we have to file some returns. The central registrar has certain powers to give directions. Those are regulatory provisions which you will find even in the company law. So we pleaded that, look, regulatory powers are not controlled. That was also accepted by CIC. Then he said that, look, this organization has taken, he took some report from Parliament in which fertilizer subsidy was reported, and he said that 15,000 crores of rupees they have taken government subsidy, and therefore there is a substantial financing by the government. That was also contested by us, that we said that this is not the kind of financial subsidy or aid that is given to an organization for running that organization. If a private company does some work for the government on contract, he is just a contractor. He is not an authority or a public authority. He is paid, and if somebody makes roads for the government, it doesn't become a public authority. So we are manufacturing fertilizer. We are supposed to sell it at the price at which we have manufactured, and the price is, say, 16,000 rupees. Government tells us that no, we want that farmers should get it at 7,000 rupees. So we are not obliged to manufacture and sell at 7,000. So this is not being paid to us. This subsidy goes to the farmers. We are only the medium, because government cannot directly approach all the millions of farmers and disperse subsidy, so they have made us a medium. And this subsidy is paid to all the fertilizer companies, regardless of their being in public sector or private sector. So if we go by that interpretation, then each individual of this country will become a public authority, because they all get some subsidy, some sort of the other, like cylinders and all gas cylinders in those days were subsidized. Finally, the CIC gave judgment in our favor. Then they filed an appeal, which was heard by the full bench of CIC. They brought Mr. Prashant Bhushan as an advocate for that. And till then, we had not engaged any advocate. I was representing that. Eventually, when we saw that Prashant Bhushan has come, then perhaps some legal battles will start, so we also had an advocate. Eventually, the board was also convinced, and that full bench of CIC was also convinced, and we got the order. Then they filed an appeal in the High Court, and there also we won the case. So if you refer to the judgments, you will find Subhash Chandra Agarwal versus and others versus IFCO. That was decided in 2015. So there we got an order, and but that doesn't mean that we giving information just for the sake of, for the heck of it. At times, we have supplied information, even if we know that we are not a public authority. We write that we are not a public authority, we are not obliged to give you information, but for your convenience, we are giving this information because we know that this information is not for any personal benefit. Sometimes somebody wants to know how leadership is given and all that. So that is in the interest of both. So there we provide the information. Now coming to the Posh. IFCO follows the policy of zero tolerance. And let me share with you one case where one lady employee complained about another employee that he has misbehaved. I mean, you will be hearing about it. What is sexual harassment? It has a very wide connotation given by the Honorable Supreme Court after this Visakha judgment. So, various acts are covered in that. That gentleman contested, then the committee investigated and gave a report in the affirmative. Now the question was, should we now conduct a full-fledged departmental inquiry and dismiss that person? Because the committee gave a report that yes, he has misbehaved or he has committed sexual harassment in accordance with the law. Now the basic problem was that confidentiality is at the core of these kinds of issues. And departmental inquiry, if you know, the principles of natural justice requires that you must disclose each and every charge in the most specific details, and then he should be given, the accused should be given an opportunity to contest. Now this was a very piquant situation for us. Our managing director said that, look, we need to give a message to other employees. So let us sack him without inquiry. And we will see whatever the consequences. So taking some shelter under some of the judgments, we wrote an order that departmental inquiry is being dispensed with in public interest and is being removed rather than being dismissed. And you will be maybe surprised or maybe happy to know that we won that case even in the Labour Court and in the High Court, despite the fact that inquiry was not done. So what I want to say is that when you come to implement a law like this, your intent should be clear and you must be prepared to complete all the ingredients that would require that law to be enforced. There are several other things that we would have discussed, but for the sake of time, I would like to stop here and request my other colleagues to be given an opportunity. Thank you very much, and thanks again to NMA for giving me this opportunity. Thanks.
Yes. So now we request our chief guest, Sri A.K. Lahoti Sahab, to say something to our delegates. Mr. A.K. Lahoti.
Thank you for inviting me to say something to the delegates. We already put the introduction to the subject as given by previous speakers. So good morning to all of you. Dignitaries dignitaries on the dais, Shri Sandeep Chitterji, Shri S.N. Singh ji, Shri R.P. Singh ji, Shri Dinesh Jain ji, Shri S.V. Mitra ji, many other luminaries who are sitting in the audience, and all the ladies and gentlemen participants in the workshop. First of all, I also compliment, like Mr. R.P. Singh said, the LMA for choosing these two very important topics for the workshop. So, these topics, as my previous speakers have said, these are transformational topics. The way we govern and the way we manage our organizations and workplaces, both these acts have a transformational effect on the entire culture. So, let me first of all say I am not an expert in these topics, and the people sitting on the dais and other persons are certainly much more informed than me. But like many of us present here, I have been running railway and being in a government organization and managing a large organization. We have been I have seen the side of compliance of these acts and sort of, I would say, managing the application of the acts in my role. So, the importance of both these acts and today's workshop, I think, is understanding the details in which the compliance of these acts is to be seen. Because both the terms are known to us, and I think they are widely discussed in the media and are common topics in any forum. But when you are managing how to apply these acts, that the details are important, and some very good illustrations, examples have been given all by previous speakers, how the real life situations of the application of these acts. And I think that shows the importance of this workshop, where the managers and participants are here, and they will get an opportunity to understand the various nuances of the application of these acts. If I talk about the RTI Act, the root of the RTI Act lies in our being a democratic country. The democracy requires informed citizenry and transparency of information to empower the citizen. It's necessary to contain corruption and to hold the public authorities accountable to the people. The term public authority, as my previous speaker said, is very important and has been widely discussed, deliberated upon, and a lot of definitions and explanations have come on definition of the term public authority. And I think one of the important examples is regarding the even private companies providing public service. They also become public authorities to that extent. So I think that aspect will be discussed with you during the course of the workshop. I will only like to say the effect of the RTI Act is, prior to the RTI Act, the tendency in the government organizations, because the RTI Act is applicable only to the government bodies, it's not applicable to the private bodies, was generally to hold the information and only disclose only what is essential for public use. The general principle was not to disclose. And when this act came, and I have seen those days, because I was also a young executive at that time in the government, and there was a lot of apprehension that once everything starts coming out in the open, what will happen? How are we going to work? And the entire mindset was governed by the British era Official Secrets Act. It was normally things were required to be kept confidential. But nothing, I would say nothing adverse happened, and I think we have become a much more transparent government, and the people have much more information about the functioning of the government, and they can hold the government much more accountable, and the public authority is much more accountable with the RTI Act. And of course, there are in the application of the RTI Act, we have to see what is not to be disclosed. And Mitra Saab has cited the principles which are to be kept in view, and of course these are adequately detailed also in the judgments, etc. What is not to be disclosed and what is to be disclosed, and those things have to be kept in mind because there are unscrupulous elements who try to use any law and for a law like RTI Act for the personal gains or for with nullified intentions, and such situations have to be dealt carefully. And there the role of PIO, the appellate authority, and the Information Commission becomes very important. And Mitra Saab has cited examples how he as PIO safeguarded the interest of the organization by dealing with RTI application. So these aspects I'm sure will be dealt and deliberated in the course of the workshop. But the RTI, I must say that the RTI Act itself has become so useful that and is covering the functioning of the government so vastly that as per the latest reports of Central Information Commission, there are almost 2,300 public authorities which are registered with the Central Information Commission, and in the year 22-23, more than 16 lakh applications were filed for right to information. And the interesting thing is that in 97% of these cases, the information was provided. So only 3% cases where the information was denied. So I think this is what I would like to say about the RTI Act. The other very important topic which has been chosen today is about the sexual harassment of women at workplaces, Prevention, Prohibition and Redressal Act of 2013. Prior to this, there was no act, but there was the Supreme Court judgment, the famous Vishaka guidelines, which were laying down the guidelines for prevention of sexual harassment at workplaces, and sort of defined what could be sexual harassment, what can be called sexual harassment, much beyond the physical contact. So that was, I think, a very important thing which came in the Supreme Court judgment, that what can be various hues and colors of sexual harassment at workplaces, and it can be not only in the public sector, it can be in the private sector, and that is what governed. Of course, but there was no act. In 2013, the act came in, and the important thing is that this act now not only covers the typical office-like environment, it is much more. The act is very wide, has a very wide coverage, and covers almost the entire organized, unorganized sector to provide a fair and free workplace for the women in our society. And as we know, it is considered that participation of women in the economic activity is very important now for the country to really achieve a high economic growth. World Bank, unfortunately, some time back brought out a report that the participation of women in the country is declining in India. But I think the method of their survey itself was under question and debated upon. Another report by Berkeley while World Bank put the figure of participation of women at around 20%, another report by Berkeley put it at around 37%, which is I think quite good for a country like ours. And World Bank we called to this hall to see the participation of women, and I was just counting, more than 50% of participants are. So, and if we go and move out in the society, I think the general impression is that the participation of women in the economic activity is good. So, it is that shows the importance of this act, that when women are working, they should not be subjected to harassment on account of their gender. So, that is the importance of this act. And again, I'm not an expert, but the legal experts are here. They will be deliberating various aspects of its application, and this applies across the sector. So therefore, it is very important. And the role of the internal complaint committees, which has been given very vast powers under the Act, and also the district complaint committees, which are for the private sector, for the unorganized sector. So that is another thing which is there, which provides the safeguards and which are very important. Again, in this case also, as we see, there are instances that we can't say that every woman employee is acting with a fair intention, and there would be errant, indisciplined women workers also, and the employer is again in this case is vulnerable to allegations of sexual harassment if he is trying to put a errant woman to work for the due work for which she is being paid for. And there the role of the internal complaint committee becomes very important, that it has to clearly distinguish whether the complaint is motivated or it's a fair harassment case. So the application has to be done with due diligence, and it should not be a biased application of the Act. That safeguard has to be there. So these are some of the aspects which I wanted to comment upon. I find the participation is quite good. Almost 50 participants are there in this workshop, and I only wonder whether one day is enough for these two topics. I think these are very vast topics, and I also feel that on the topic of sexual harassment of women at workplaces, the more number of participants should be from the male side, because it's for this particular application of this Act, more than the complaint side and the redressal investigation side, I think the more important aspect is educating the people about what constitutes sexual harassment, educating them how to conduct themselves while dealing with women at workplaces. This is what is important, and I think this education is completely lacking in a formal way in our society, and that needs to be propagated further. With this, I wish all the participants and the organizers success in this endeavor and a very successful workshop. Thank you so much.
Thank you so much, our chief guest, Sri A.K. Lahoti Sahab, for giving insight into the RTI Act and the Sexual Harassment of Women Act. Now we shall break for tea, and after 15 minutes we shall again join. Before we break for tea, our host Mr. Mittal Sahab and Sri SN Singh Sahab also to be honored.
पर आपके घर आती हो